So we've heard a lot about Brett Kavanaugh over the last few days, including for the President of the United States last night. So we know a fair amount about his track record, about what goes on his CV. You've worked closely with this man. Tell us what we don't know about him.
Well, we began to see this last night, David, and that is he is, first and foremost, a great human being. And what you saw last night and heard last night is really what you get in Brett Kavanaugh. He's totally intellectually honest. He's not full of himself. Some people in Washington, D.C. and elsewhere, even in Waco, Texas, can be a little bit overly full of themselves, but he has this wonderful spirit, a sweet and kind spirit. He's always worried about the other person and so forth. He's going to wear very well. And the other thing about him is that he is so incredibly hardworking. He paid tribute to his father last night. He's smart. To say he's smart is an understatement, but he's not just smart. He's as prolific a worker and prodigious a performer as I've ever worked with.
So one of the things we also got a glimpse of last night is what I would call the judicial temperament question.
Right.
Because everyone who comes to the bench, you did it when you came to the D.C. Circuit, comes with their experience. You want them to come with their experience.
Yes.
At the same time, you want them to be somewhat open to challenging their prior views and being willing to persuade it, particularly by the other 8 people up in the Supreme Court. Is he willing to be persuaded that maybe what he thought was the case is no longer the case?
Oh, absolutely. I found that he was very open-minded. Again, this goes with intellectual honesty, as opposed to bringing an agenda, and this is the way I'm looking at the world. I think you will find in Brett and Judge Kavanaugh, and hopefully Justice Kavanaugh, a genuine interest in what is the issue. Let's analyze it carefully, and let's see if we can't find the best answer. At times in the law, as you well know, you even get the right answer. But you can usually find, all things considered, given the facts and the law, the better answer. But the other thing is he believes very much in the process of deliberation and reasoning. His training on the 12 years as a judge, he was obviously a law clerk, and we share that experience, and it's great, but there's nothing like actually being in the conference room as a judge in deliberation with your colleagues. 2, or however, if you're sitting as a full court, it could be as many as 12, that you're sitting with and you're having a very serious conversation that you know is so important, not just to the parties, but to the law. How do we decide this case?
At the same time, he does have quite a body of record here. He's got 300 opinions, basically, we heard last night, 300 decisions on the record. So he's indicated how he thinks about some of these issues.
Yes.
Place him in a larger context of a conservative tradition of judging. Where does he stand in that, and what does that tell us about how he might make decisions going forward?
I think he stands in what I like to think of as the grand tradition in constitutional law, in modern constitutional law. And I actually begin with Holmes and Brandeis and Cardozo, and what were they saying? Frankfurter, Byron White, appointed by President John Kennedy, and that is, let's allow the legislatures and we the people to govern ourselves, but then let's take the Bill of Rights very seriously. So I think you'll see a very capacious interpretation of the Bill of Rights, not grudging. People were surprised, for example, about Justice Scalia being such a robust defender of Fourth Amendment rights, that no, the government always wins. No, not at all, because we the people, are to be free from unreasonable searches and seizures. And so the interpretation of that was given in a number of decisions in the Supreme Court a very broad, surprisingly broad breadth. I think Brett will fit into that same kind, I should say Judge Kavanaugh, will fit into that same kind of mode of someone who takes democratic processes very seriously and yet is going to be a fervent defender of individual rights.
Because he sat on the D.C. Circuit, perhaps, there's quite a bit of a track record with respect to administrative law, as we call it, the rulings on agencies and the extent to which independent agencies can or cannot do things. And he's well known, for example, for his CFPP decision, striking it down, saying it's not sufficiently subject to the president's direction. How important is this challenge, as it's being made, to what some people call the fourth branch of government, that is, the independent agencies that are not subject to really the Congress or the president directly?
One of his big issues and principles, I should say, is accountability. Is power being exercised in an accountable way? And especially with the growth of the administrative state, really beginning in the New Deal, but then continuing almost without any interruption whatsoever in the development of independent agencies, Brett is, because of his rootedness in the rights of we the people and self-government values, wants to see accountability in government. And I think that is a unifying theme that we're likely to see on the Supreme Court.
Well, that's interesting. A unifying theme when you talk about, for example, Chief Justice Roberts, who's really talked about the Commerce Clause maybe being taken too far. Is there a growing majority, forget conservative liberal, is there a growing majority for this notion we really do need to take a hard look at how far the administrative state, as you say, has gone?
I don't think there's any question. Even Justice Kennedy, who had, I think, embraced principles of deference to administrative agencies, began expressing concerns as time went on. So I think this is going to be a very lively conversation among the justices, and we'll see that in the case law. But I expect there to be a trend now in the 21st century toward much greater accountability on the part of agencies being reversed by the courts. We're seeing it, I believe, more than was the case, say, during the age of Justice White. I'd like to use him as sort of an anchor. I call him the last New Dealer. So he went on in the 1960s under President Kennedy, and his view was the agencies are almost always right.
So finally, and briefly, given your experience and your experience with Judge Kavanaugh, there is entirely possible that we will have before the Supreme Court questions about separation of power when it comes to investigating a president. We have investigations right now of President Trump involving so-called Russian collusion, questions of collusion. Do you anticipate the possibility that really there would be issues coming out of that investigation that would rise to the level of the Supreme Court, like a Pentagon Papers case, that really question the executive prerogative?
It could be. Obviously, it's speculative at this point. But, David, I do see the possibility, if there is a confrontation, the issuance of a subpoena to the president, of a major separation of powers issue. Can, in fact, an officer within the executive branch, the special counsel, Mr. Mueller, actually subpoena a president of the United States? It's an unresolved question.